The United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-7129, Timothy Skrynnikov, appellant, versus Federal National Mortgage Association. Mr. Salve for the appellant, Mr. Churchill for the appellee.
Good morning, Your Honors.
Good morning.
Please the court. I'm Micah Salve. I represent plaintiff Tim Skrynnikov. I'd like to reserve 4 minutes for rebuttal. Your Honors, when an employer bars an employee from returning to work at the expiration of his or her FMLA protected leave period, the employer has interfered with the employee's exercise of his FMLA rights. In a scenario like that, the employee has satisfied his or her burden to present a prima facie case of FMLA violation. And at that point, the burden shifts to the employer to try to demonstrate that its actions were legitimate. But Fannie Mae cannot do that in this case.
Didn't it, Fannie Mae argues in its brief that the job was eliminated.
Fannie Mae
the position was automated and eliminated, and I didn't see a response to that in your reply.
I beg your pardon, Your Honor.
Did I miss something?
Your Honor, I don't think, I'm not sure that Fannie Mae actually made that argument, only that that was the reason for not returning him. Maybe this is a distinction without much meaning, but far more important.
Definitely.
Far more important, Your Honor, is the law that governs such claims. In order to demonstrate that an employee was removed for some other legitimate reason, which of course is perfectly acceptable in an FMLA scenario, right, you have to demonstrate that the job did not exist when the employee was ready to return.
Is your point that they didn't prove that in the district court? Because that's what they argue in their appellate brief, that the job no longer existed. Isn't that its argument?
That's correct. And, but there was
what did you say in your reply brief?
I'm afraid I don't remember the words of my reply brief well enough to answer that question, Your Honor, but I will say that this argument was proffered by the defendant without any evidentiary support, but more importantly,
well, see,
the law requires.
That's why I asked you the question. I would have expected you to respond to that.
I'm sorry.
Brief, and I didn't see that.
There was no evidentiary support for that claim, mm-hmm. And in fact, the evidence shows that they advertised this same position after Mr. Skrynnikov was fired. He received a phone call from a headhunter saying, "Hey, this job looks really good for you." And he said, "Yeah, it sure does, because it was my job."
So I'm sorry, I have the end of a cold, so my voice is weak. But you said, Mr. Salve, that the employer would have to prove that the job no longer existed when the employee was ready to return to work. I'm not sure I'm following the importance of the timing. If the employee returned to work and one day later the employer said, "Getting rid of your job," why wouldn't that be equally a full defense? Why does the timing when the employee was ready to return to work? And let me just put my cards on the table. It seems to me that Fannie Mae wanted to allow Mr. Skrynnikov to take the paid leave under its policy. He could have terminated the job and gotten rid of him earlier, but it afforded him the full period paid disability leave before formally eliminating the job.
I'm not
What's
sure
wrong with that?
Well, I'm not sure that that's factually correct, Judge Ballard, because in fact, he was covered by this leave policy, and there's no evidence in the record that he would have ceased to be covered by whatever leave policy. Of course, FMLA leave is not ipso facto paid leave. And if Mr. Skrynnikov was being paid, there's just nothing in the record that indicates that they had any desire for him to be paid or for him to continue to be paid. But
No, I'm just saying.
as to the legal,
My real question is how you characterize the employer's burden that it had to prove the job no longer exists when the employee was ready to return to work.
Can't
it just show at any time that the job no longer exists and that's its prerogative?
Yes, absolutely, Your Honor. It is absolutely the employer's prerogative to terminate, to have a reduction in force whenever there is a legitimate termination of a job, or for that matter, if Fannie Mae believed that Mr. Skrynnikov's job performance was inadequate or that his attitude was bad, they could have fired him at any time, even while he was on leave. They didn't do so. They didn't do so because there wasn't evidence in the record to support that. Now, as to the issue of the timing,
I just don't understand that argument. I'm sorry. That didn't make any sense to me.
Judge Tatel, when somebody's out on FMLA leave,
Yeah.
they're still subject to the ordinary vicissitudes of employment, right?
Yeah.
If there's a reduction in force, you're out of luck. You don't get special protection because you're on FMLA leave.
Yeah.
However, if the employer wants to say, hey, we got rid of this employee for legitimate reasons,
Yeah.
then first and foremost, the employer has to prove that as a matter of fact. And there's no evidence in the record to support that claim. Second,
Is the arbitration proceedings not evidence?
it does. And there was a bald assertion by one of the witnesses that that was the reason that they chose not to keep him after his leave period expired. That was what the testimony.
Well, there was testimony by Lori Mallon about and Carrie Lee and Kristen Harrison about automating the position.
Automating?
Yeah, that's what they said was the reason.
I think there's also testimony from Mr. Skrynnikov indicating that he was hired in part to implement that automation. But that automation affected only a very small part of his job. But what's, I think, more important is that Fannie Mae does not hang its hat on having legitimately terminated Mr. Skrynnikov. They claim that it was proper for them to terminate him because he didn't submit his FMLA leave return to duty, fitness for duty certification in time.
That can't be why they terminated him, because he was given all his federal and DC FMLA leave and also given the short-term disability leave. He got all of that. They gave it all to him. So that can't be, and it wasn't until he returned that they then fired him listing this other reason.
No, Judge Millett. He had used up his full period of federal FMLA leave. He was then in the position of...
They gave him all of his DC FMLA leave too, retroactively, but they gave it all to him.
That is true.
Okay.
I mean, I would...
I think they also gave him some of the short-term disability leave too, did they not? He got till what, November 1st?
I missed that last thing.
He was out until November 1st.
I don't know whether, in fact, he received any short-term disability leave afterwards, but I don't
Regardless,
think that's material.
and that's right. Regardless, he got all of his
This claim
leave.
is not a denial of leave allowance. This is a claim for denial of job restoration rights and for interference. What Fannie Mae did in that...
How is it interference if he got all the leave? At the end of the day, he got it all.
The interference was in his right to be restored to his job.
So the interference claim is the same as what you called his restoration claim. There's one claim. He had a
Well-
right to be restored.
Yeah, I mean, I think as a matter of semantics, I would say that there are two different claims, but effectively they're
The
covered.
argument is exactly the same, is that he wasn't given his job back.
He wasn't given his job back, and they interfered with his efforts to return to work.
Okay, for your interference claims, I get it. There's two categories. For the interference claims, you cite, you rely on McFadden and Gordon, and those cases require that you show prejudice for your interference claims, right?
I'm sorry, I didn't hear you.
I'm sorry. Those cases that you cite for the burden of proof require that you show prejudice. These are for the interference claim, correct?
Yes.
And where have you done that?
Okay. First, I'm not entirely sure that the law in this circuit requires a showing of prejudice.
I was just relying on the cases that you cite.
Okay, but Your Honor,
don't you cite those cases?
I suspect I did. I'll rely on the court's statement. Your Honor, the prejudice is clear. By interfering with Mr. Skrynnikov's ability to come back to work, by barring him from returning to work, Fannie Mae caused him to stay out after his leave period had expired, and therefore he was susceptible of termination for failure to return at the end of his FMLA leave period.
Okay, thank you.
Thank you, Your Honor.
We'll hear from counsel for Fannie Mae.
May it please the court. Fannie Mae gave Mr. Skrynnikov all that he was entitled to under federal and DC law. The only entitlement with which Fannie Mae allegedly interfered is Mr. Skrynnikov's right to return from protected leave in the period from October 26th to 29th, 2009. This interference claim fails for two independent reasons. First, the record shows that Mr. Skrynnikov was trying to stay out of work until November. Second, DC law imposes none of the procedural requirements that Fannie Mae allegedly violated. Because the first argument is factual, I'd note at the outset Mr. Skrynnikov's agreement on page 4 of his reply that none of the facts on which the district court relied in its opinion are disputed. And this includes the fact that Mr. Skrynnikov went to an urgent care facility and specifically asked for a note allowing him to stay out of work until November 2nd, even though he had already been told by an emergency room that he was medically fit for duty as soon as October 16th. The district court concluded...
So, I understand his claim. He wasn't trying to get further medical leave. He just wanted to take vacation.
Yeah.
And so he's done with his medical leave, and he just says, I'm uncomfortable. Yeah, it could work. And I'm uncomfortable because I have broken ribs, and I have accrued medical leave, and just in my life, I just rather use that now. And then there's this sort of, jerking him around a bit on whether he needs a separate fitness for duty relating to the ribs. And that ends up without telling him during this whole process, actually, we're limiting your job, and actually, you don't need to justify taking your vacation time. It seems like it really was unprofessional at least. How can you explain how Fannie Mae conducted this?
Your Honor, I'd like to respond in two ways. First, Fannie Mae did tell Mr. Skrynnikov how he could obtain the vacation time if he wanted to continue pursuing that route.
Talk to the manager.
Yes, exactly. Speak with the manager. And it's undisputed that he didn't continue to pursue that. Second, the district court found, and I believe it's undisputed, that Fannie Mae required a return to work certification pursuant to its standard policy and practice, acting out of a concern about a duty to ensure that when people come back to the workplace after expressing medical concerns, that it's safe for them and for other employees. The record also shows
After expressing medical concerns, that's if you're taking medical leave, isn't it?
Your Honor, an employee doesn't have to expressly invoke the FMLA or the DC FMLA.
If they're seeking medical leave in terms or not, but here he made clear he wasn't seeking medical He was seeking vacation.
I think initially vacation was a possibility that he put out there. When he raised that he wanted time out of work for medical reasons, Fannie Mae understood that it had an obligation to determine whether he was entitled to medical leave and, on the other hand, whether he was safe to return to work. They didn't want to prevent him from taking advantage of the rights to which he was entitled under statute or under the company's short-term disability policy, and burn vacation time unnecessarily if that was an option that was available to him.
Let me just say, look, here's one way of reading the record. Potentially, you tell me why I'm wrong. Okay, Mr. Skrynnikov. So all the problems started when he, taking the facts in light most favorable to him, wanted to be the truth teller and was concerned that a supervisor wasn't. That he was shunted off into taking leave, some kind of formal leave when he just wanted to use his vacation time by Fannie Mae. And Fannie Mae, and this is in the record, told Reed Group, the special case, special scrutiny. Look at him, his claims, with an exacting eye. Fannie Mae interfered with and overrode Reed Group judgments in a way that it hadn't traditionally, and seemed to be imposing a bunch of ad hoc requirements. And there's a very short time between the end of protected leave and termination. Why isn't that enough to meet a summary judgment, Gordon?
Your Honor, if I could reply, there are several parts of that question, and I'll try to respond in three parts. As for the origin of this issue being Mr. Skrynnikov's desire to ensure that the truth is told to the Senate, and a conflict with his manager over that issue. First of all, he withdrew the claim with prejudice.
I'm not saying it's a False Claims Act claim. I'm talking about the record here, that Fannie Mae had reason to be irritated with him, to want to get rid of him, be upset with him, to give him special scrutiny, not in a positive way. All right, so I'm not asserting a False Claims Act. That doesn't respond to what I'm saying here is the summary judgment evidence that he's come forward with. Why isn't that enough to defeat Fannie Mae's claim for summary judgment?
As to the merits of the truth-telling issue, the contemporaneous record, including Mr. Skrynnikov's notes from the April 28th meeting, where he alleges he discussed this with the manager, the complaints that he submitted to Fannie Mae's ethics and compliance, all the contemporaneous records say nothing about what was being reported to the Senate. He actually complained that he was being discriminated against on the basis of national origin, which is a claim he chose not to pursue further. It's undisputed that his responsibilities have been automated. I think trying to read in an alternate reason for his termination is not supported.
Why does it matter that this position was automated? Because the Family Medical Leave Act doesn't require reinstatement to the exact position, as long as it's sort of an equivalent position. So saying this particular one was automated is no answer to the duty to reinstate him.
Yeah, as to that, I think you're right. The record doesn't address, and Mr. Skrynnikov agreed this could be decided on summary judgment. The record as it's been developed doesn't address the existence of equivalent roles. I think that's
whose burden was it to show that there was not a role to which he could be returned? Because Fannie Mae just says, well, we automated yours. Do you have a case or something to help me understand how that is sufficient or responsive under statutory requirements that simply be that he be restored to an equivalent, the same or equivalent position?
Your Honor, I don't, standing here today.
Don't you have to have that?
No, I don't think so, because the record shows that Mr. Skrynnikov was terminated after his leave was exhausted. And so,
sure, but if we write an opinion that says as long as you wait 24 hours after they come back to work or 48 hours and then terminate them, then we're good with that. And you can terminate them because they can't go to the exact position, even though that's not the test on the Family Medical Leave Act. That would seem to really gut I'm just using collectively the two FMLAs similar requirements of restoration to an equivalent position. To simply say, you can just get rid of the one position and just wait 48 hours.
I think this maybe brings us back to two other parts of your initial question. You mentioned the language about the high level of scrutiny, the special case, and the sensitive case. If you look in the record at pages 501, 503, also 639 to 40 of the joint appendix, what you see is undisputed testimony. The term special case and sensitive case were used to refer to a situation where the company thought there was actually a chance that medical leave might be exhausted. And the reason to apply high scrutiny is to make sure
it's not undisputed. The fact used to be drawn from those emails is not remotely undisputed. He has a very different reading of what that meant. You're not telling me that's undisputed, are you?
There's no controverting evidence. I agree, he has a different read. But
what evidence did you put into the record that that's what special scrutiny meant?
So
did you have a declaration or testimony or something like that?
Testimony of the arbitration, the joint appendix citations that I provided. Okay. Then turning to, give me just one moment.
Mm-hmm.
You mentioned the ad hoc requirements, and the district court did determine that the requirements Fannie Mae imposed were pursuant to their standing policy. The policies in the record indicate that Fannie Mae required an employee who raises a medical concern to be referred to regroup for evaluation. And this was something which applied across the board. It was not expressly used to target Mr. Skrynnikov in any special way. Your Honor, to see my time is.
Yep. Anything else? Okay, thank you.
Thank you, Your Honor.
Let's see, Mr. Salb, I think you were out of time, but we'll give you 2 minutes if you'd like.
Thank you, Your Honor. I don't know any lawyer who would not like.
Well, sometimes they say they don't prefer to do.
I'm happy to talk.
2 minutes. 2 minutes.
There are a couple of points that I'd like to make in reply. First, Fannie Mae says, when we learned that Mr. Skrynnikov had a rib injury, we had a duty to do something about it. Perhaps so. If we presume that to be true, that duty does not include abridging FMLA rights. The policy says we refer the regroup. He went to the regroup, and the regroup sent him away saying, no, you're fine. You don't need anything else. And Fannie Mae overruled the regroup. Now, that overruling is particularly telling because the undisputed testimony was that the regroup's job was to make final determinations regarding leave. Final determinations, not recommendations, not suggestions. Final determinations. So Fannie Mae's overruling of the regroup on several occasions and frequently accompanied by what I can describe only as nonsensical explanation is evidence of mendacity and also shows that there wasn't a legitimate basis for rejecting Mr. Skrynnikov's return on that basis.
I just have one thing I want to make clear here, or to make sure I understand clearly here. The relief you want from this court is it to enter a summary judgment in your favor, direct the entry of summary judgment in your favor? Is that your argument, or is it that, no, we need to go back and have a trial? There's clearly disputed facts here that are relevant.
I think that the only way to read the facts in this case is in Mr. Skrynnikov's favor. I do believe that that it was error not to grant summary judgment because none of the facts that are in dispute, the extent that either the facts themselves or maybe the read from the facts are in dispute, are material.
Okay, so that's what you're seeking. You're not seeking
Well,
trial.
obviously, I'll take what I can get.
Well, you had your trial thing and you said you wanted summary judgment instead. So that's why I'm just trying to understand. So your burden on this appeal is to show that the district court erred in not granting summary judgment for you on this record.
Yes, Your Honor.
Okay.
I believe that the district court erred both in granting summary judgment to Fannie Mae, and if that's as far as this court goes, then it would be a return for a new proceeding. Perhaps if this court believes that there are facts in dispute, then the proceeding would have to be a trial before a jury instead of on the papers. If this court agrees with me that there's no way to read the facts in this case other than in Mr. Skrynnikov's favor, then this court should grant summary judgment to Mr.
So, Mr. Saub, you said you thought there was no record evidence that the job had been automated, and I'm looking at the Fannie Mae's statement of material facts not in dispute, where they say by the third quarter or so of 2009, the work was fully automated, primarily fully automated. And I don't take Mr. Skrynnikov's corresponding statement of material facts not in dispute to take issue with that. Just says he doesn't think it's relevant. And I don't see how it could be not relevant if there's a legitimate independent reason. And as you acknowledged in your primary argument, of course, the employer retains the prerogative to let an employee go when they no longer need the employee. So what is your position in light of, at least in my reading, the fact that there is evidence in the record fully automated the job?
Oh, there are a few points, Your Honor. First, I don't think it's fair to say that that issue is responsive to the gravamen of our complaint. Our complaint is that Fannie Mae interfered with Mr. Skrynnikov's return to work. He wants to come back. They say, no, first you need to provide this.
Right, but even granting everything you say, you're right on everything you say, but independently, the job has evaporated. And Mr. Skrynnikov has never said, what about another job? I want to come back to another job. Then what is how does he clear that hurdle that for reasons unrelated to his leave, he's being let go?
I think one of the issues, and part of the reason I'm sort of struggling with this, is that this statement that his job had been eliminated was entirely post hoc. That occurred, that issue, that factual assertion arose only at the mediation.
This is not an intent case the way you've litigated it. It's an interference case. So I'm not sure the post hocness matters.
I think it does, Your Honor.
Why?
Because when they state throughout the period where they're tussling, Mr. Skrynnikov, you need to provide a fitness for duty certification. Reed Group says, no, you don't. You're fine. You're cleared to go back. Fannie Mae says, oh, no, we're going to overrule. In fact, they lied. They said, no, the Reed Group says you do need a return to work certification. So then they direct the Reed Group to demand that. Now we have this back and forth, which, as you can imagine, I'd love to go through and endlessly and share with you, but you've read it in the briefs. There's this long back and forth. Never once does Fannie Mae say a word about his job having been eliminated, about him no longer being needed. This issue arose when Fannie Mae was looking for a defense after the fact. And it is simply a post hoc rationalization.
Finish your sentence, unless there's any further questions.
Thank you, Judge.
Thank you. Thank you, gentlemen. The case is submitted. Yeah, of course. Ann, could we just take a pause here for a minute? We have a malfunctioning computer, and it isn't mine.
You may just take a second.
You don't have to remain standing.
Okay. All right, I'm going to send a test. Can you make sure it goes? I'm going to send it. Make sure. We're good to go.
Ready to go?
Ready to go.
Hey, Ann,
Thank you. Sorry about
call
that.
the case. Thank you.
This honorable court is again in session. Case number 21-1122 et al. New Fortress Energy Inc. petitioner versus Federal Energy Regulatory Commission. Mr. Zworecki for the petitioner, Mr. Solomon for the respondent.
Good morning, Your Honors. May it please the
Good
Court.
morning.
Shai Dvoretsky on behalf of New Fortress Energy. If I could, I'd like to reserve 3 minutes for rebuttal. This case arises from FERC's failure to follow its precedent. Shell made clear, based on history, Supreme Court case law, and the common understanding of natural gas facilities, that the Commission's authority under Section 3 of the Natural Gas Act reaches only LNG facilities that are connected to a pipeline. Since Shell, FERC has applied that requirement consistently. No pipeline, no jurisdiction. But that's not the test that FERC applied here. Instead, FERC applied a new piping of any kind requirement. What's more, FERC moved the goalposts without
Why do
acknowledging
you say piping of any kind? FERC's view is that it's a pipeline. Period. It transports gas, therefore it's a pipeline. Yeah, a short one, but it's a pipeline. I don't understand why you say it's piping of any kind. It's just a shorter pipeline than a longer pipeline.
In Shell itself, the Shell decision never uses the word piping.
Well, but in Shell, as I understand, on the Lake Michigan facility, that's the one that's relevant, right? Because that's an import facility. There just wasn't a pipeline, correct?
There was not a pipeline.
Yeah, so there wasn't one there, and there is one here. So why aren't they perfectly consistent?
I think it goes to the fundamental difference in the industry and in common usage between the term pipeline and what a pipe is.
FERC says a pipeline is a pipe that transmits gas. Period. And it's interpreting its own precedent, which FERC says in no way depends on the characteristics of the pipeline. The only question is gas transmitted by pipeline, or in which case it's jurisdictional, or is it transmitted by boat or train, in which case it isn't. It seems, pardon the expression, simple.
Judge Tatel, I think that when
What am I missing? Tell me what I'm missing.
When Shell used the term pipeline repeatedly,
Yeah,
first of all,
but there wasn't a pipeline in the Lake Michigan facility in Shell.
I understand.
Okay.
But the term pipeline has to be understood against the common usage in the industry of what that means, against the history of the statute that FERC explained in the Shell decision, and even in light of the Shell decision's own language when talking about the Geismar facility, when describing short segments of pipe.
Yeah, that was the interstate facility, right?
That's right.
Right, which doesn't relate to the issue in the Michigan facility or this case.
But what I think it does relate to is the Commission's own use of language. The Commission used the word pipeline repeatedly, 23 times in the opinion. In talking about the Geismar facility, it talked about short segments of pipe. Those are not the same thing. They're also not the same thing in Supreme Court case law. The Supreme Court in the Phillips decision talked about pipelines. It also talked about segments of pipe. The history.
You have a case where they talked about pipeline in this way, where there was a short pipe or a short segment like this. And they said, no, that's not a pipeline. I mean, you point to a lot of cases where there were great big things that look like great big complicated pipelines. But what you don't have is precedent where they've said, if it's short or it's a single pipe, that can never be a pipeline. Do you?
We don't have that case because there is not a case that I'm aware of before this one in which FERC has attempted to assert jurisdiction over a pipe rather than a pipeline. And that's not surprising.
In Southern LNG in 2010, they said, when companies construct a pipeline to transport import or export volumes, only a small segment of the pipeline close to the border is deemed to be the import or export facility for which Section 3 authorization is necessary. They pretty much thought there that a small segment of a pipeline would be sufficient to trigger Section 3 authority.
But not a freestanding, independent 75-foot pipe of the sort that you have.
But you don't have any.
Suppose this pipeline, suppose, according to your terminology, this pipe was much longer and actually went for hundreds of miles across Puerto Rico. Would we have a different case? Same diameter, just 100 miles long, to a power plant. In other words, it was delivering gas to a power plant 100 miles long. Different case?
I think as a matter of physics, if you had one that was running hundreds of miles, it would likely have a larger diameter, just reflecting the volume and pressure.
Forget the diameter issue. I'm sorry I brought that up. Say twice the diameter, okay? But going 100 miles across the island. Yes? Pipeline?
I think if we were talking 100 miles or more, that's likely a pipeline.
Okay, how about 50?
But there is.
How about 50?
I think 50 probably is a pipeline.
And what about 25?
Probably a pipeline.
Okay,
as well.
one?
I think one's a much closer case. There is some.
What's the standard you're applying here? FERC's standard is simple. If it's a pipe that transmits gas, it's jurisdictional. And I didn't see you cite any case, maybe you can tell me one, where FERC's decision relied not on the distinction between pipeline and other methods of transportation, but on the characteristics of the pipeline. Now, I know you cite cases where they discuss the different characteristics of a pipeline, but is there a case that you can cite where FERC jurisdictional decision turned on the characteristics?
No, Judge Tatel, but there's also not a case before this one in which FERC has said that the standard is any type of piping as opposed to a pipeline.
It's always said pipeline.
It has said pipeline, and pipeline as a matter of judicial, industry, and common usage means a large-scale transportation system.
Since you say there is no case, then I'm not sure how we could accept your argument that they departed from precedent.
I think the baseline precedent is that in Shell, the commission was talking about a pipeline and what a pipeline means, what it means to the commission in numerous decisions that the commission has issued, what it means to courts, what it means to the industry.
But when you say what it means in for common usage, I'm not at all clear what the common industry usage is. I think you just cited the FERC cases. And so, since FERC cases were simply describing the facts before them, and there isn't a case where they said, if it's only 75 feet, it won't be a pipeline. Then I was struggling as I read your brief to find where this evidence of a contrary common usage is in their decisions. I mean, it so happens that most of the time there's multiple pipes and they're longer and bigger, but it so happens doesn't mean that that's definitional, let alone jurisdictionally definitional, does it?
Judge Millett, I think it's helpful to look at how the commission itself in Shell justified the pipeline requirements. And when it talked about pipelines, it was talking about large-scale transmission systems that typically cross state lines, which is how companies evaded state regulation over these pipelines. That was the concern that Congress was trying to target in granting the commission jurisdiction. So when the commission uses the term pipeline, when it applies the pipeline requirement, that is what it means.
Excuse me, but I didn't think this case had to do with interstate shipment. Isn't this an import facility?
It is.
So it's a different, so what you're talking about doesn't relate to the question in this case, does it?
The commission also explained in Shell, I think this is in paragraph 40, that the same standard for pipeline for section 7, which deals with interstate transmission, will also apply to section 3, which deals with foreign importation, which is what we have here. I think
Let me ask you,
Isn't there? Go ahead. Go ahead, David.
No.
Isn't there a procedural opportunity where New Fortress could have sought a FERC declaratory order establishing the jurisdiction. It was puzzling to me because there was a lot of lawyering around the threshold, decision whether to go with New Fortress and where to cite the facility. Why wasn't a FERC declaratory order sought on this issue? It mattered a lot.
2 points, Judge Pillard. One, there was a lot of lawyering, not only by New Fortress, but also by PREPA, and the FERC staff provided assurances that if the 75-foot pipe would likely not be considered a pipeline. So there was a lot of lawyering, and FERC staff read FERC's orders the same way that we do, which is that there's a distinction between a pipeline and a pipe. In addition to that, while a declaratory ruling is something that can be sought, those take a very long time. And in fact, there's no deadline by which the commission ever has to rule on it.
We're familiar with those issues of deadline and FERC. But at the time, am I wrong that there was a lot of focus on the gas being trucked elsewhere? Was it less prominent in people's minds at that time whether it would be also substantially fueling the adjacent power plant? It seemed like that was less prominent at the time that this decision was being made.
No, Judge Pillard, I think it was clear to commission staff that that's what we were talking about. The joint appendix, I think 51 to 59, this is where the history of these dealings with commission staff is recounted. And while trucking was discussed, so too was the 75-foot pipe. New Fortress submitted to FERC a memo submitted to FERC staff a memo summarizing the discussions, restating what staff's position had been. Staff didn't object and say, actually, no, we think there's a question about this. So there was quite a lot of assurance going into this project that it would not be jurisdictional. And while there is no precedent involving a pipe of this length, at the same time, there is also no example of FERC asserting jurisdiction over a facility with a pipe of this length. There is no example of somebody seeking a declaratory ruling.
What is if you could just step back and give me the common sense importance of the assertion of jurisdiction? Like what rides on this? I mean, here they've said we wouldn't require the plant to stop, but is this all about NEPA? What else hinges on whether the facility is jurisdictional or not? What's the substance of the regulatory regime that's triggered?
Sure. So I think the threshold question is that if the facility is subject to FERC's jurisdiction, then it can't be operated without submitting an application that FERC reviews and approves. That is a lengthy, expensive process that's currently ongoing. There is, of course, no guarantee that FERC will approve the facility or that it will approve the facility without modification.
Why not? What is it looking at other than environment? Or is it principally the environmental impacts? What else is it looking at? Safety? Is it looking at national security? I mean, I know I should read the law and know this, but it's not really in the briefs what the practical issue is here.
So I think as a practical matter, there's a significant amount of data that FERC seeks to collect about the operation of the facility. There's a lot of back and forth between FERC and New Fortress's lawyers. In addition, as a practical matter, when you have a jurisdictional facility, if New Fortress wanted in some way to expand the facility, it would need approval from FERC for that. If New Fortress wanted to sell the facility, it would need approval for that. And so there are significant consequences to being a regulated entity in this space.
Do you have to comply with NEPA as well?
I'm sorry?
Would you have to comply with
Yes.
NEPA now as well?
So as I read your brief, your basic argument is the one you've made here today, which is that FERC's decision here represents a dramatic change in policy. And you say that several times throughout the brief in several different ways. If I don't agree with you about that, is there any other argument that you have other than that? In other words, if it's not a change in policy, if we think this decision is consistent with previous policy, perhaps an explanation of it, consistent. Does that end the case?
It does not.
Would you just list for us what the other arguments are?
Sure. So one argument is that under this court's decision in the American gas case, FERC has an obligation to respond to the views, to the arguments raised by a dissenting
Okay,
commissioner.
good point. Now, let me just ask you about that. The way I read it, FERC didn't mention, I don't think FERC mentioned the dissent, but FERC's position is we responded to the issues raised by the dissent because they were the same as the issues that you raised. Is that not accurate?
I think that's not accurate. And I also think not only did FERC not name Commissioner Dam, the entire...
Well, you're not serious about that argument, are you?
The entire...
Do we have a case that says that for FERC to satisfy its obligation to respond to a dissent, it has to name the dissenter?
I think the point is not whether the dissenter is named.
Well, you just said it. That's why I asked you the question.
But I think the point here is not only didn't they name him, but they didn't respond to his substantive arguments.
Well, FERC says they did because they were the same arguments raised by the parties. And what argument did the dissenter make that FERC didn't respond to?
The dissent argued, as FERC did. I'm sorry, the dissent argued, as New Fortress did.
Right.
That there is a distinction between pipes and pipelines. FERC's response to that was that the distinction is not relevant. Period.
Yeah, that's the same argument.
It wasn't relevant.
See?
I think they explained why it wasn't relevant.
Exactly. Okay, so what's the next argument that's not a change in policy?
Well, if I may just briefly respond to what I think was Judge Pillard's question. The problem with saying it's not relevant is that they didn't give an explanation for why it isn't relevant that we are dealing here with something that is not a pipeline, but rather a 75-foot.
They said it's not relevant because the question isn't the character of the pipeline, it's the distinction between pipeline and other modes of transportation. Now, you don't agree with that. I understand that, but FERC responded to it.
Oh, but not only do I not agree with that, but I also don't agree that that explanation is in the order. That's an explanation that is offered by the briefs.
Right.
That's not an explanation that the commission provided.
But this is all, but the discussion we're having is in response to my question about whether the commission adequately responded to the dissenter. I take your point that you don't think their response was adequate, but FERC responded to the argument the dissenter was making because, as you just pointed out, you made the same argument. So let's just keep going. Is there another argument that you want to be sure we don't miss?
Just to finish on the dissenting commissioner point, I think the point is FERC didn't adequately respond to either argument.
I understand that. I understand. What's the second argument? What's another argument that you want to be sure we don't miss?
Sure. So if you think that the commission did not depart from precedent in Shell,
right,
then in this case, it's simply applying the same standard that it applied in Shell, which is the pipeline standard. Then as a substantive matter, it is an unreasonable conclusion to say that a 75-foot by 10-inch pipe is a pipeline. In other words, FERC did one of two things.
That's different from your primary argument?
Yes, because FERC did one of two things here. It either changed the pipeline requirement to an any type of piping test. That is a different test that it hasn't adequately explained. Or if it didn't do that, and you think that it adhered to the pipeline requirement, then it is improperly applying the pipeline standard to the facility that we have at issue here.
What's the third? Is there another argument?
So I think the last argument that I would make is FERC has come up with a standardless rule here because it hasn't given us.
No, I was asking you if we think this is consistent with FERC's case precedent, then that answers that question. I mean, that means that the standard they're applying here is a standard they applied in Shell. And so that's really not a different argument.
I think it's a different argument because what this case then shows is that the standard applied in Shell is the standard that applies in Shell is not a coherent standard because FERC has never explained what constitutes a pipeline. It hasn't explained.
Okay. You have anything else? No. Okay, thank you. Go ahead. No, go ahead.
Mr. Doreski, you said that the argument that they make about the physical characteristics being not relevant is not an argument that's in the order, but I see it in the order at JA 109 to 110, where they talk about rebut the argument that your client made that design specifications, length, diameter of pipe matter. And the commission says we've not ever considered that to matter. That relates to the volume, but Section 3 has no minimum size limit. Rather, we're looking at whether a pipeline is engaged in transportation or there's some other function. And so it basically does explain its not relevant understanding. So I guess I'm not following why you say they just brushed it off as irrelevant, rather than saying, this wasn't transferred by truck or train or boat because the end user got it by pipe.
Judge Pillard, I think you're looking at paragraph 23 of the
In part,
original order.
ensuing paragraphs.
Yeah, and I make a couple of points about paragraph 23. One, the commission says here that it has never considered physical characteristics. I would point you again to the language in Shell, where the commission was talking about pipelines in one place, but it was talking about short segments of pipe in another. And even though the short segments of pipe discussion was in the discussion of the Geismar facility, the point is that the commission has taken into account, it has distinguished between pipes and pipelines. And in a sense, it has to, because when we're talking about a pipeline, we're talking about something that inherently is defined by its physical characteristics. So of course, when you're looking at a facility, you have to ask, does this facility have the physical characteristics of a pipeline? So it's simply not true to say that the commission has never considered physical characteristics. The language in Shell itself shows that it has. As for the language about sections 3 and 7 not having a minimum size requirement, but what Shell says is that they do have a pipeline requirement. That's how the commission interpreted sections 3 and 7 in Shell.
In the domestic context.
In both contexts. Again, I take you back to paragraph 40 of Shell. It starts with the domestic context, that's section 7, but then in paragraph 40, the commission is saying that it is applying the same understanding of pipeline from section 7 to section 3, which is what's at issue here. And so we have the same understanding of pipeline for both in that respect. And you have the Shell decision itself, again, talking about pipeline and talking about short segments of pipe. Again, what I would say is you have to take into account the physical characteristics because there's no other way to understand what a pipeline is. Other
Well,
than
I think I mentioned the Southern LNG case, which is cited in FERC's brief. And that case itself then cites, after it makes that point about just a short segment of pipeline is all that's needed. It cites other cases, including a FERC case that granted Section 3 authorization for a 30-foot pipe, 30-foot by 4-inch diameter pipe. That's the Sword Energy case. The New Mexico case was a 150-foot pipe, in their words, with an 8-inch diameter. So it seems like, at least in the Section 3 context, which is all we have to decide before us, pipes, boats too, and even smaller than the pipe at issue here, have been held to be sufficient to trigger Section 3 authority. And so doesn't that just, you may want them to care about the characteristics, but they don't. And so your core argument would have to be not that it's standardless, because they clearly have said pipes of any length in this case and in others, and simply that you would have to argue that's just beyond their authority under the statute to reach just a pipe, a single pipe of these relative diameters. But you haven't made that argument, have you?
No, the main argument that we're making is that if they're going to reach just a simple pipeline, they have to provide an explanation for why the statute does that. In Shell, they provided an explanation for why the statute reaches pipelines, but not.
Why isn't the explanation they gave adequate? They say, maybe I'm wrong about this, but the explanation they give is that it's transmission by pipeline. It's not transmission by boat or truck. That's their explanation. Why isn't that enough?
Judge Tatel, that's not the explanation that the commission gave in its order. That is an explanation that the commission has argued in its brief. That is not the explanation that the commission gave. If I may briefly respond to Judge Millett on FERC's cases. So I think there are two different categories of cases that FERC is relying on. One is the Aguirre and the Ecoelectrica case. Those are ones where an application was submitted to FERC. There was at most cursory analysis of jurisdiction. Those were not developed analyses of whether FERC had jurisdictional authority. And the pipelines at issue there were over 1 mile and 4 miles long, respectively. So that doesn't tell us what to do with a 75-mile pipe. There may be some gray area between a pipe and a pipeline, but 75 feet is out of it. The other cases that I believe you're citing don't appear anywhere in the orders. Those are cases that the commission is relying on for the first time in its appellate brief. And in addition to that, all of those cases involve.
I know,
your
but
question.
is it true under Chenery we don't come up with reasons? But if in fact it's a matter of objective record, FERC has other cases where it's exercised Section 3 authority over even smaller pipes. Do we have to turn our head away and ignore those just because they didn't cite the cases? As long as it's not adding any more reason. It's just confirming their reasoning.
I think if FERC wants to say the reason that we can exercise jurisdiction over this facility with pipe is, look, we've done it before, that's a reason that they ought to give in their order. But I also think those cases don't support the point because, as Your Honor's quotes from the cases suggested, those cases are dealing with segments of pipe that are connected to a larger pipeline. You have a branch system. Those are not cases involving freestanding, independent 75-foot segments of pipe. You're just talking about a segment of pipe that connects to a larger system. And it's that larger system that makes it.
Okay, thanks. We'll hear from FERC.
May it please the court, Robert Solomon for the commission. I think Your Honors well understand the agency's points and the agency's explanations. Judge Tatel, you are correct. All that matters for purposes of whether this is an LNG import facility is whether the 75-foot pipe transports gas. What the commission explained is that the pipeline rule is not simply that there be a pipeline somewhere of some indeterminate length. Rather, what the commission explained in the Shell case and explained in the orders on review is that a pipeline for this purpose is one that enables the LNG facility, if it's an export facility, to receive gas for liquefaction. And if the facility is an import facility, whether the pipeline enables the facility to send away gas after it has been vaporized. Judge Tatel, you asked whether there is really at bottom any issue other than simply whether the commission has changed its policy. And I submit that that is, in fact, the only question that petitioner raises. The other issues, such as reliance and response to the dissenting commissioner, those all devolve back to the issue of whether the commission changed its policy.
Mr. Solomon, if this is so clear, why was there so much confusion when the company and the Puerto Rican government were conferring with FERC up front? It seems like the FERC senior staff got it wrong. And I'm just curious why that is, if the issue is so clear.
Well, on the record, I'm not so certain that the FERC staff got it wrong. And I believe in your questions to petitioner, the actual mechanics and characteristics of the facility were evolving in 2017. The plan was to have trucks take away the capacity. The commitment with the Puerto Rican Power Authority to fuel its San Juan plant wasn't developed until 2018. So I submit that the record is somewhat more equivocal. You can find this on JA9, where you have the testimony of the Power Authority. But even taking New Fortress at its word as to its recollection of the meeting, Judge Pillard, I think you were correct in focusing on whether and why not New Fortress didn't petition for a declaratory order. Everybody agrees that Shell is the leading authority here. The Shell order was in response to a petition for a declaratory order. Indeed, the other leading cases, the 2014 and 2015 pivotal LNG cases, the Amera case, the Andalusian case, those were all orders in response to.
How long does it take to get one of these declaratory orders? How long does it take on average to get one of these declaratory orders?
Petitioner suggests that New Fortress didn't file because it would take a long time. I am not aware of any particular extreme length of time in issuing a declaratory order, and I think the commission would be responsive to a plea for expedition if the declaratory order petition is premised on having a decision on jurisdiction by a certain time so that financial.
Have you seen cases like this where parties ask for expedited declaratory order and they get them? Have you seen that happen?
Yes, the commission does try to oblige.
Do you have a sense then of how expedited that is? I mean, are we talking 6 months, a year? I mean, they have a lot on their plate. 2 years. I just don't have any sense of. I'm not asking you to sort of commit off the top of your head. I'm just trying to get some sense for myself.
If an applicant files a petition for a declaratory order and says that the applicant needs a FERC response in 2 months or 3 months, the commission will try to oblige. The one thing we don't want to receive is some type of petition for writ of mandamus, and I believe that the commission has been quite timely in the cases that I mentioned. There was no claim from the applicant that the commission acted in an untimely manner. The petitioner here is well represented by qualified lawyers. The regulations are clear that when the applicant seeks the informal advice from commission staff, that those are not the official views of the commission. The other thing New Fortress could have done, other than petitioning for a declaratory order, is to file its application. If the commission thought that there wasn't a jurisdictional basis for acting on that application, the commission would have done what it did in the 2013 Hawaii case, the gas company case. It would have dismissed the application for want of jurisdiction.
Well, counsel's argument is that preparing an application is big and complex, and they want a jurisdictional finding before they go through that.
Well, if they want a jurisdictional finding before they have to go through the effort of filing an application, the vehicle is to petition for a declaratory.
Okay. Is that significant to the case we have before us today in some way? I'm not
Excuse
sure.
me, is there something so significant?
Yeah. What's the significance of that? The issue, we have a clean, straightforward legal question before us today about the FERC's decision, right? We have a petition for review of that decision. Are you arguing that because they didn't seek a declaratory opinion that's somehow relevant to how we handle this case?
No, it really isn't relevant to the jurisdictional question presented. We're just responding to the argument of the petitioner, who argues that the commission's decision was unfair, that it came out of the blue. Judge Millett, you asked whether there are any cases where the commission found that a short piece of pipe is not a pipeline, and there are no such cases. And in fact, the Shell case itself said in paragraph 38, note 71, that the length of the pipe, for purposes of section 7, not section 3, but the length of the pipe, actually using the word pipe, does not matter. In the interstate context, all that matters is that the pipe connect to the interstate grid. In the foreign commerce context, all that matters is that the pipe be able to deliver natural gas in natural gas form.
The Southern LNG case, which you cite in your brief, but just for a different proposition, makes the point about just needing, in section 3, you just need a segment of pipeline to be enough to sort of bridge the import line. It doesn't have to be the whole pipeline, just a segment. And then it cites a number of other FERC decisions, including ones that have relied on pipe of, one was 150 feet, one was 30 feet long. Can we acknowledge the existence of those decisions since the commission didn't cite them, or is that a Chenery problem?
Well, the commission, of course, said that the physical characteristics don't matter. The common usage of the word doesn't matter because we're dealing with a particular context here, a section 3 LNG terminal in foreign commerce. But we're further responding to petitioner's argument that...
I'm just asking you whether we can look at, in reviewing a decision that asks about the body of FERC decisional rulings, are we allowed to look at ones that FERC didn't cite? Does Chenery mean we can't even look at cases?
Well, you certainly don't need to look.
That's not my question. I'm really asking. I'm trying. This is just a weird take on Chenery I haven't thought about before, so I really am interested in your opinion.
Well, from a Chenery perspective, the commission said that the physical characteristics don't matter, that the common usage of the word...
I'm aware of what the commission said. I'm asking you, if it seems to me that, in fact, the commission has already crossed this bridge even before this case.
Right. I will say the commission has, yes.
In cases that are cited in a case you cite, is that something in addressing arguments about common understanding, FERC's, departure from precedent that we can even take notice of or not? I just am asking this Chenery question. Not whether I have to. Does Chenery even say ignore? Normally it says reasoning. That's discussion, but ignore the body of case law.
Well, the commission did not say that a smaller pipe measured in feet can be a pipeline. So there is the Chenery issue. But this also goes to the point that the commission did say.
Is it a Chenery problem if elsewhere the commission has said that's sufficient to trigger section 3?
I would think that would be a problem elsewhere. But again, the issue here is that a pipeline for this particular purpose is one that transports gas and differentiates between the pipeline mode and the truck, train, and ship mode, where the gas is delivered in liquid form. What the commission did in the Shell case was to look at the history of pipeline regulation under the Natural Gas Act, which was enacted in 1938, when the only form of delivery of gas was in a stationary, non-mobile pipeline manner. And the commission found that it didn't want to engraft other modes of delivery. I do want to point out that the pipeline test is just one of the factors in a three-part test. if the concern is interstate commerce as opposed to foreign commerce, there is a fourth step, whether there is a connection.
The commission had, and this is just a clearly hypothetical case, had a case and they said, we're making a new rule. We've never addressed this as a question of first impression. And then adopted Rule X. And it turned out that there were actually 10 prior FERC cases that said, no, the rule is not X. But because the commission in the case before us didn't cite those other ones, would we avert our eyes to the existence of those under Chenery?
No, I don't think you would avert your eyes, but the standard for a change is that the commission first acknowledge and recognize and then explain. If the basis for the FERC order was that it is changing its policy, I think you would review the order based upon the commission's motivation. If in fact there were pre-existing cases such that the commission erred in thinking that it had changed its policy when it really hadn't, I have to believe that that's something that the reviewing court would be able to take into account, because in fact the commission would not be changing its policy. But here, the commission explained the basis for the rule, explained the application of the rule to New Fortress, and explained in its orders that in fact there was no departure from the rule, and that is all that matters for purposes of review in this particular case.
Okay, thank you. Let's see. Mr. Dvorsky, I think you were out of time, but you can have 2 minutes.
Thank you. If I could, I'd like to make 4 quick points. One, Mr. Solomon pointed to PREPA's testimony in the record at Joint Appendix 9. If you look at that testimony, it is talking about what was presented to FERC staff, and the understanding of the facility was that gas would be delivered from the vaporizer through power plant piping located entirely within San Juan Power Station property. Staff representatives focused on the absence of a natural gas pipeline extending a substantial distance, suggesting that the absence of such facilities would make it less likely that the commission would assert jurisdiction. Our meeting left us confident that in FERC staff's view, the configuration which NFE ultimately proposed made it like other LNG facilities which the commission had concluded did not require its authorization. So the interactions with FERC staff were clear, and FERC staff understood Shell to mean what we understand it to mean. Second,
FERC's own regulations say that they can't speak for the commission, right?
I'm sorry, Judge Hale.
FERC's own regulations say they can't speak for the commission.
They can't speak for the commission, but I think this supports the argument that what FERC has done here is a departure, and FERC's own staff understood it that way.
Well, but that's reversing the standard. I mean, you can't be right about that. If they can't speak for the staff, you can't use what they said. If they can't speak for the commission, you can't use what the staff said to argue the commission has changed its position.
I think what the regulations provide is that you can't rely in an estoppel sort of way on what the staff says, but I do think that the evidence what the staff says is relevant evidence.
You have 3 more points. Go ahead.
Second, Shell rooted the pipeline requirement in history. The commission has to similarly explain how a piping of any kind requirement, which is the test they applied here, comports with that history and with the statute. Third, Mr. Solomon relied on footnote 71 of Shell. If you look at footnote 71 and at the text in paragraph 38, it says, quote, all of the liquefaction facilities over which the commission has exercised Section 7 jurisdiction have had pipeline interconnections with the interstate pipeline grid. So what footnote 71 is talking about, as I was trying to explain to Judge Millett earlier, when you have a short segment of pipe that connects a facility to the interstate grid, that's one thing. But that's not the same thing as what we have here, where you have an independent freestanding short pipe. Last point I would make, and this goes back to Judge Tatel, your question earlier about Commissioner Danley's dissent. Commissioner Danley pointed to common usage. He pointed to dictionary definitions. The commission didn't engage with anything. Also, in paragraph 18, talked about this very point that in Shell, the commission thought it was very significant whether you had a pipeline that connected to the interstate transportation system. He specifically raised that point in paragraph 8 of his dissent. The FERC's order doesn't respond to that argument in explaining why that connection is no longer
Why would that matter? What matters when you're talking about import is not the interstate system, but the boundary between foreign and domestic.
Because the commission in Shell, and this is again in paragraphs 40 to 43, said that the same standard for Section 7 applies to Section 3. When Congress added the definition of LNG terminal in 2005, it didn't mean to change that understanding. And that's what the commission expressly said in Shell, that it was applying the same standard. That is the standard on which the industry has relied and built up expectation. The commission now wants to depart from that. It needs to explain itself, and it's failed to do so.
Mr. Dvorsky, Mr. Solomon, thank you. The case is submitted.